Hi, I'm Kenny. In this video, I'm gonna introduce another pair of basic concepts in Canada immigration field: burden of proof and standard of proof. Unlike another pair of concepts that I have discussed in another video, eligibility and admissibility, burden of proof and standard of proof are completely different concepts. They are independent from each other and they share nothing in common. What do they mean? How would they affect our Canada immigration applications? Let's find out. Let's first look at the burden of proof. From the name, we can guess it probably means the responsibility to present evidence to prove something. Unlike the presumption of innocence that is used in criminality determination proceeding, in Canada immigration field, the burden of proof in most cases is on the applicant. Let's see how the law says about this. This is the Division 1 of the IRPA, Requirements and Selection. Article 11 says, a foreign national must, before entering Canada, apply to an officer for a visa or for any other document required by the regulations. The visa or document may be issued if, following an examination, the officer is satisfied that the foreign national is not inadmissible and meets the requirements of this act. As you can see, a foreign national must apply to an officer. This is where the burden of proof works. It means that it's the applicant's responsibility to establish they meet the admissibility requirements and the eligibility requirements. It is not the visa officer's responsibility to prove the contrary to refuse their applications. Let's look at another application form for a Canada immigration program. This is a document checklist for the permanent residence application under the Quebec Selected Self-Employed and Federal Self-Employed Persons category. The name of this form is IMM 5784. In the relevant experience section, there is a note saying, the onus is on you to produce documentation to support your experience in one of these areas. This note clearly states that the burden of proof is on the applicant, not on the visa officer. Someone may say it's kind of like a presumption of guilt. Well, it may sound that way, but we need to understand that for a foreign national to enter and remain in Canada is always a privilege, not a basic human right. So if you want to get some privilege, you are gonna earn it through the application during which you need to take the burden of proof. Now let's talk about the standard of proof. Standard of proof means a certain level of strength of evidence required to prove a certain chance that something has occurred in the past, is occurring at the moment, or may occur in the future. This is a wording from the Article 33 of the IRPA. Now let's look at a chart. It uses a mark to show the chance of something to occur, from 0% to 100%. And there are in total 4 different levels of standard of proof. Starting with the minimum level, it's called mere suspicion. From the chart we can see it's very near by 10% or 20%. But for sure it's above the 0. And probably it's less than 1/4, where it simply means you don't have any evidence and you just have a very subjective opinion, which is very weak. The next level is reasonable grounds, so it's close but less than 50%. And it's probably more than 1/4, so it's just between 1/4 and 50%. It means you just have some reasonable grounds, but it's not accumulated to a very high standard. The next level we come at the balance of probabilities. From the chart, it's about nearby 60% or 70%. However, balance of probabilities has another name, that is more likely than not. So even if you just got 51% or 52% or 55%, you have reached the balance of probabilities, as long as you got more than 50%. But as we can see from the chart, it's probably less than 3/4. The highest level of standard of proof is beyond a reasonable doubt. As we can see from the chart, it's somewhere between 3/4 and 100%. This level of standard of proof is often used in criminality determination proceeding, and I don't think we are gonna use it in Canada immigration field. This concept of standard of proof might be too abstract to understand. Now I will use an example to help. As we all know, in Canada, your private property is protected by the law. When you buy or rent a house, the house and the land beneath the house and the surrounding yard and driveway are all your property to be protected. No one should enter your property without your consent. Now let's say one day you are sitting on your couch and looking outside the window, and then a stranger is approaching your house. He may look ugly, weird, and even suspicious, so you don't think he is a good man. However, so far, you have no evidence or reasonable grounds to believe he is a bad guy. You can only merely suspect this. So to this point, your standard of proof is just a mere suspicion. And the next moment, this man just enters your property, let's say enter your yard or your driveway, because there is no fence and it's easy to get in. And without your permit, he even stays there for a while. Now you can say that you have a reasonable ground to believe he might be a bad guy, because he enters your property without your consent and you don't know him. However, you still can't say that he is more likely than not a bad guy, and even he is planning for a crime or something. The next moment, this man takes out a shovel out of his backpack and starts digging in your yard. And he digs out something out of your yard and put it back in his backpack. To this point, you might say that he is more likely than not a bad guy, because he enters your property without your consent. And he even took out something out of your yard into his backpack. But you still can't say that he is beyond reasonable doubts that he is a bad guy, or he committed a crime. Why? Because you called the 911, and the police officer comes in. After checking out, this stranger just digs some dog's poop out of your yard, and he is taking those waste away from your yard, so that's a good thing. And he turned out to be doing something good. It's just a misunderstanding. This example may not be very appropriate and precise at all, but I believe to some extent you have now learned the concepts of different levels of standard of proof. If you have any question or comments, please do let me know. So far, you may ask, how is the standard of proof applied in Canada immigration? And how can we use that to prove that we satisfy the requirements to get our applications approved? Well, let's take an example. As we all know that for all temporary resident applications, the applicant has to satisfy the visa officer that they are gonna leave Canada by the end of the authorized stay. For the visitor visa application, this is stipulated in the Section 2 of Article 179 of the IRPR. For the study permit application, this is stipulated in the subsection B of Section 1 of Article 200 of the IRPR. For the work permit, this is stipulated in the subsection B of Section 1 of Article 216 of the IRPR. Well, how can we prove that we are gonna leave Canada by the end of the authorized stay long before we enter Canada? It's impossible for us to prove that 100% that we will definitely leave Canada. That's not possible. And fortunately, we don't need to do that, because in Canada immigration field, the default standard of proof which is applied in most cases. And in this case as well, we only need to prove that we are gonna leave Canada by the end of the authorized stay on balance of probabilities, which means more likely than not. That is to say, we just need to prove that we will more likely leave Canada by the end of the authorized stay than not to leave Canada by the end of the authorized stay. Does it sound easier? Let's take a practical example. Some people may heard such a saying that if you are applying for a Canada visit visa and you have never been abroad before, so you are holding a blank passport, in these cases, you are not gonna get approved at all. I have seen and heard many agencies suggesting the clients to do an international travel before they apply for a Canadian visit visa to avoid a blank passport. Is it true? Well, let me put it this way. Most of my clients applying for a Canadian visit visa are holders of blank passport, and so far, all of their applications for the visit visa had been successfully approved. The Canada visit visa is the first visa stamped on their blank passport. And let me explain why. First of all, we need to understand how a blank passport affects your application for a visit visa. That is because on one hand, you have never been abroad before, so you need to explain why you choose Canada as your first overseas destination for a sightseeing travel instead of other countries. This would be especially challenging if you are living in a country that is very far from Canada. For example, if you are from Asia or Africa, because normally people wouldn't choose a very far place to do the sightseeing for their very first international travel due to the long distance and the very high travel expenses. And on the other hand, due to the lack of the international travel history, you cannot prove that you will obey the Canada law and leave Canada in time, in that you never did that before. Well, this is where the problem comes in. Just like I discussed just now, you don't need to prove that you will leave Canada in time beyond reasonable doubt. And a blank passport can only constitute a reasonable doubt. So it does not prevent you from proving that you will leave Canada in time on a balance of probabilities. If you are a holder of a blank passport and you are interested in applying for a Canada visit visa, I will have a course prepared for you. So stay tuned. Always keep in mind that the standard of proof in many cases is more likely than not. However, to secure a higher successful chance, in my practice, I always pursue a higher standard of proof when presenting my client's case. Why? Because the standard of proof can be very subjective. For example, I believe my case has reached 51% of standard of proof, but the visa officer just believed that I only make a 49% case. That would of course bring a refusal for me, because it's always the visa officer who makes the call, and the different visa officer may think differently. So how can I ensure a higher successful chance? There is only one answer, and the answer is very simple. Always try your best to pursue a higher standard of proof. Because if you can make a case beyond reasonable doubt, that's above at least 3/4. Let's say you make an 80% case. And even if the visa officer takes you 30% away, you will still get a 56% case. That is still more likely than not, and you can get it approved. So don't be lazy, don't hope for a stroke of luck. Always believing in law, and believe you are doing the right thing. Although the default standard of proof in Canada immigration field is balance of probabilities, which is also more likely than not. Is there any other standard of proof in Canada immigration field? The answer is yes. I will explain it in the following video. So stay tuned. I'm Kenny. Learn my lessons on your way to Canada. See you in next video.